Good morning. I think we'll go ahead and get started. Thank you to all of those who've joined. It's a pleasure for me to welcome you to this panel on this really critical topic for our times. I just wanted to do a few housekeeping notes before we get started. So if you'd like to put questions in the chat box, we'll try to circle back to those questions once we are near sort of the conclusion of our kind of opening remarks and questions. So feel free to place your questions throughout the panel in the chat, and know that we'll circle back to them later on. It is again my great pleasure to sort of introduce you to the panel on the meaning of diversity, equity, and inclusion in international law. The panel is sponsored by the American branch of the International Law Association Committee on Teaching International Law and the Permanent Mission of Colombia to the United Nations. We have a really impressive and extraordinary group of panelists. It's my privilege to be able to moderate this panel, given the sort of wealth of experience that the panelists bring to this subject. Let me start by introducing them. Ambassador Namira Negm is the legal counsel for the African Union. She has a PhD in international law from the University of London and became the first woman ever to assume responsibility of the Office of Legal Counsel of the AU. Her accomplishment was not only a milestone for Egyptian women, but for women in Africa and all over the world. The former Egyptian ambassador to Rwanda has also worked as the head of the anti-corruption unit at the Ministry of Foreign Affairs of Egypt and the legal advisor to the Egyptian mission to the UN in New York. Welcome, Ambassador. We also have Professor Monica Pinto. Ms. Pinto is a professor of international law and human rights at the Law School of the University of Buenos Aires, where she currently serves as the dean. She also serves as special rapporteur on the independence of judges and lawyers for the UN High Commissioner on Human Rights. She was appointed to that post in 2015. She sits at the administrative tribunals of the World Bank and the Inter-American Development Bank. And she has appeared as legal counsel and expert before a variety of human rights bodies, arbitral tribunals, and the International Court of Justice. She's been awarded honors by the French, as well as the Goler T. Butcher Medal by the American Society of International Law for her engagement and contribution to the field of international human rights law. She's also published numerous books and articles. We also have Professor Anna Spain Bradley. She's Vice Chancellor for Equity, Diversity, and Inclusion, and Chief Diversity Officer at UCLA. Ms. Bradley is the Vice Chancellor, as I mentioned, and Professor of Law, but she also leads and advances strategies for enhancing equity, diversity, and inclusion in this post, and oversees the university's mechanisms for upholding civil rights protections. She's an expert on international law and human rights, and her current research actually focuses on global understandings of racism as a violation of human rights, and is the topic of her book, Global Racism, which is forthcoming from Oxford University Press. She was also a legal expert at the United Nations and practiced international law as an attorney at the US Department of State Office of the Legal Advisor, where she received 2 meritorious honor awards for her work. And she was also a delegate to the UN Compensation Commission in Geneva. In 2021, she was elected as a vice president of the American Society of International Law, having previously served on the executive council. Last but not at all least, we have Daniel Stewart, who is the founder of Independent International Legal Advocates. Daniel founded this organization in 2017 after many years working in international law at the United Nations. He's a graduate of Harvard and Columbia Universities. He worked at the Special Court of Sierra Leone and the Extraordinary Chambers in the Courts of Cambodia, the European Court of Human Rights, the Constitutional Court of South Africa, and the Supreme Court of Israel, as well as the International Court of Justice. He regularly teaches courses on various aspects of international law, including human rights law at Columbia Law School, as well as Cardozo and St. John's Law Schools and the New School. With this extraordinary panel, it's hard to sort of focus on a few specific questions. So we will do that, but at first I wanted to give each of the panelists a chance to sort of tell us about their own personal journeys and experiences as an attorney, as a human being, sort of encountering these issues. I was curious to know specifically sort of how you see this conversation evolving from your perspective, and how far have we come in this discourse? What do you think in terms of your own experiences as related to diversity, equity, and inclusion? So with that, let me start with Monica Pinto. If you could please give us a sense of sort of how you feel about this and how it's affected you personally.
Thank you so much. It's a great pleasure to be here. Thank you so much for the invitation to the panel, and it's my great pleasure to be with all of you here. As you've heard, I'm a law professor, and I'm based in Buenos Aires, Argentina, where I passed the great majority of my life. And I'm a woman, and that will be my point of view today. We had always been there as students, as professors, as professionals. We decided to be mothers, and life complicated a little bit. And when we first had the first child with the flu, and that happened when an important meeting was scheduled, we had to speculate between being honest. Listen, my girl is not feeling well, and I will be staying with her. Can we reschedule the meeting? Or trying to skip the meeting on other grounds. I'm so sorry, but I have an urgent matter to be dealt with immediately. Half of the male universe helped us to be honest, but the other half. Afterwards, law firms and corporations put in place their diversity committee, and we learned that we, who had been there from the creation, we were the cause of diversity. Our personal efforts and those of the organized movement of women, the increasing impact of human rights in everyday activities have helped to create a culture in which we respect each other and consider each other equal while acknowledging our differences. Culture takes long to be created and to be modified. We should not act and react as males to be considered on equal footing. We should be considered equals while being ourselves. National policies come to help, but also partners. We have to choose very carefully our partners in life and in profession. We women, we got a very robust set of international legal rules acknowledging our rights and freedoms, which has been mirrored in many countries. Still, the practice is not easy in many parts of the world. The news these days told us about a young woman who has been murdered by her family members because she liked to wear jeans. The difficulty of the practice is that states have to help with an important and supportive speech, but non-state actors, human beings, corporations, as we used to say in international vocabulary, have a say there. To reduce the problem to the non-discrimination field is oversimplifying it. The point is the lack of power. Inequality means lack of power in the public and in the private world. What about other groups? LGBTIQ+, whose situation improved because of the impact of the Yogyakarta principles. But this pandemic has made it explicit. Anyone can be in a situation of vulnerability. When in 1945 a new legal and political order was established, it embodied two issues that would change international and personal relations: self-determination and human rights. In both situations, the other has to be considered as ourselves. And it is because we still do not understand quite well that we can be the other and be in the other's position, that we need to move forward with the speech and with the actions of diversity, equity, and inclusion. I'd like to close with some words by a Nigerian novelist, Chimamanda Ngozi Adichie, and I will be quoting. The single story creates stereotypes, and the problems with the stereotypes is not that they are untrue, but that they are incomplete. Thank you so much.
Thank you so much, Monica. That was a moving story about your own experience. And of course, I love the quote at the end. It's so true about the incompleteness. And I think that we all sort of fight against those stereotypes throughout our lives. And not, as you quoted, not necessarily because they don't have any merit, but because they're so flawed in terms of revealing sort of the complete human being. So with that, let me turn it over to Namira. Namira, would love to hear your thoughts. You've sort of broken barriers throughout your life in terms of what you've accomplished, and curious to hear how you did that, how you managed to get to where you are, facing the challenges that you face, as well as sort of what it reveals about our larger sort of cultural conversation and our discourse. So over to you.
Thank you very much, Suhini, and thank you very much for inviting me to be on this panel. It's very distinguished, so I'm very happy to be with you today. Maybe I will start from a point where Professor Pinto referred to in relation to self-determination. Because if we speak about diversity as such, now we are speaking about the diversity and the inclusion within the context of human rights, but not when it comes to the mind of practitioners, for example. This is something that comes to my mind when I hear diversity or equity and inclusion. It will come in my mind in relation to the political rights of states, if we are talking about the international arena, what type of involvement other partners will be within the state. But I will keep that later to the discussion because we have one question on state sovereignty. But when we are speaking about the perspective of the diversity of the individual, as an individual and as a female, as you mentioned, yes, we all encounter a lot of problems. Maybe like our idea when we were younger, life is more florid, and we think that it would be easier to go into equal level of education, equal opportunities when it comes to work, but it's not the case. We are fought mostly in a lot of contexts. I will give you some examples from my personal experience. When I joined the Ministry of Foreign Affairs, one of my relatives was asking me, and mind you, his more senior ambassador was asking whether my family will allow me to travel or not. So I looked at him and I said, my grandma traveled alone in the 1900s, we're talking about 1919 and before, to get her degree from the UK. So now I'm the third generation and my family will not allow me to travel. Why? It's just because I'm a single woman. So that shows you the perception in a community. Of course, again, in another context, someone also I worked with had to tell me in my face, I don't believe in working women. I was like, what shall I do? Am I compelled to resign or change my gender or what to do? It's just very weird that you are faced with a boss telling you this. And we are talking about the context that is exposed to the world, which is supposed to be in a way more advanced in the way they think. Sometimes, like in some discussions, even internally in relation to legal systems, if you speak about women's rights, like it's very funny that you see male parliamentarians or very nicely Western dressed males. And it's nice when they speak about women's rights or different rights in the salon. But when we go to a meeting where we are negotiating a law that will give women more independence or more rights when it comes to the family law, oh my God, then you find them we're getting back to the Middle Ages. It's like a different ball game. And the funny thing is, which is something I have also encountered in my life, when you have people when to dress it, be it the tradition, be it the religion, in any format. And that is the funny thing. When you bring them, for example, in a community with a majority of Muslims, you bring them verses from the Quran, telling them, no, here, God himself said we're equal. So why are you depriving me from that right? So this is something that it's like we keep encountering this on daily basis. Now, moving to the context of the African Union, I will save you the details, but this is on a continental wide organization. And funny enough, apart of course from the political context, but also when it comes to gender, like you can find some of my colleagues are just annoyed because I'm a female and I'm in a big position. As you said, I'm the first female legal counsel. And I even didn't realize that this position in the African Union has massive mandate and very influential. But that is the funny thing. Like, I can be in a meeting where you can see, you feel that people are like the males around you are trying to deal with you in a condescending manner. I have so many females, juniors in my office, and I don't allow any senior member in the commission to attack them or step on them. And once someone, God bless his soul now, but I actually, when I had a report from one of my colleagues that he stepped on her in a meeting and he didn't want to give her the floor and so on with member states, when I saw him afterwards, I told him, listen, don't ever touch my stuff. As long as we are there, they represent me and they represent the Office of the Legal Counsel, then they have the right to speak and to address member states when they are called for. The guy was shocked that I will be that strong defending my female staff. So, but that is the reality. You can see that every day, and you have to keep fighting and to prove yourself to an extent that you are capable of what you're doing. And at the same time, especially when you're younger, you have to do double effort. As Professor Pinto said, when you are talking about your excuse for anything, is very difficult to bring family matters. And it's the funny thing is, if it's our male colleague saying, oh, I have to take my wife to the hospital, it's acceptable. But if I'm saying I'm going to the hospital because I have any problem, or what type of problem? If it is in relation to motherhood, if it's in relation to being a female, you have to hide it. You have to try to window dress it and bring another excuse. Again, it's still, we have some development, yes, but maybe the rules sometimes are even more advanced than traditions and reality. I'll stop at that.
Thank you so much for that. You certainly have broken a lot of glass ceilings and inspired, I think, probably a generation of women. And certainly when folks, I think, defend young staff, young lawyers, it makes a huge difference. And you know, you learn by example. So I think, you know, they carry on that defense of their peers as they move forward in their careers. So thank you for all of that. I think that was really helpful. We're going to pivot a little bit. So in full disclosure, you know, I'm currently the senior policy advisor to the U.S. ambassador to the United Nations, but prior to that, I was fortunate enough to collaborate with one of our panelists, Daniel Stewart, in an organization that he founded called International Independent Legal Advisors. And what struck me about this organization was that it actually took the lens of diversity and applied it to the states within the UN system. So the idea was really to ensure the inclusion of states and peoples on the globe who typically don't have a real voice or a strong voice in, you know, UN negotiations. And so it was a really compelling organization from that perspective. And so with that, I think I'll hand it over to Daniel to talk a little bit about what prompted him to found this organization in 2017 and sort of his experience working on international law issues with respect to this topic. Daniel?
Thank you, Sohini. Thank you for the full disclosure. It's a pleasure to be here. Thank you for the affirmative action policing of. I'm not going to spend a while talking about the challenges of being a white British man in the field of international law. Those things are changing. So, Sohini, I think I approach this quite differently, in a positive for me, obviously, the easier life route in that respect. And I came to law, international law. This is the way I'm talked about, slightly older than I look per se, but you're young, idealistic. And, I saw it purely through the lens of law at the global level and how it could bring, just, fair, sustainable solutions. And then you sort of enter the international law firmament with those ideals and recognize in institutions, both academic, international courts and tribunals, and then, as you said, sort of in the UN, the challenges of turning that, sort of utopian fairyland into a reality, and across a bunch of different levels. And as I think we'll definitely all talk more about the composition of, and that's certainly what Professor Pinto and Professor Go talked about, the composition of those bodies and those challenges. But, I think the challenge of converting formal sovereign and or state equality into a reality of what equity might mean in terms of, that basic human equality translated then into how do we perpetuate and really make those kind of changes. It was quite quick to see some of those challenges in institutions first. And I think you asked, Sini, how far have we gone? I think probably the greatest leaps have been on a sort of internal institutional personnel perspective, beyond obviously the places where, there has to be sort of formal, equality in terms of, groups of states and equal numbers of the different regional groups. But even on the staffing levels, that has been improved, if generally still at the younger or more junior level. And that will take, unfortunately, decades probably to filter into the highest points. We'll get to that. But beyond that, what does diversity and equity mean, as you sort of said, and realizing that the sort of the making and then the using of international law, we set these, not every international law, but generally these sort of grandiose goals of what we can achieve with it. But the reality of, I think there's something to be said, and for obviously the, celebrating, for example, the fact that, people always use like Tuvalu and China both have one voice in the General Assembly. The reality of then on a day-to-day lives example of how much the voice of those peoples are able to participate is so severely, affected. Now, that sort of raises and try to focus and think through, even though not implementing a bunch of different forms of those. One about within any representative groups, whether that's for a state, one of the non-state actors, Professor Pinto talked about how representative are the individuals who speak on behalf of the state really are. Again, you can see different states or different international non-governmental organizations, some more or less representative of the kind of diversity, and we'll get to a certain form, but certainly in racial grounds, gender grounds, ethnic grounds, others much, much less so. And then within those states, how representative are those, how much do they speak for all the peoples, communities, groups within their own state? Again, some states much better, some groups much better than others. So how do you build that in, again, without sort of this forced democratic mandate? And then beyond that, equally saying that if we really want to sort of achieve sort of equity based on that full human equality, this sort of formal sovereign equality, and that's what in all these institutions you're seeing, in fact, can be a hindrance or an obstacle to that. That's not something which is sort of easy to perpetuate. And working within the staffing levels of international organization, in fact, you're constantly reminded both internally and externally from states, of course, that that you are just there to serve them. And so it was that kind of concerns, desires for effectuating that change that sort of led me to found ILA, only in the sense of, in the long run, as long as we have states, and certainly accepting that that's a reality for now, and I'm not trying to get rid of them necessarily, that there are a certain number of states who are able to really shape both the content, and that has been always true, and I think continues to be true, as well as then the day-to-day management, using development, all the interesting, exciting stuff that, without really enabling the sort of voice of the peoples through the representatives, through the states, the small developing states, will just continue to sort of have only sort of a surface level of diversity. And a last comment at this sort of starting level, I would also say that not as important as the sort of obstacles that both Professor Pinto and Professor Ngem raised, is that also, I think we'll get to this as well, that there is a certain sense of, uniformity or orthodoxy in the conception of international law automatically doing good by its sort of mere existence. And I think in that sense, there has been some advances, but there's still a long way to go to appreciate, and again, let's say younger generations, that, whether or not international law really does lead to these just, fair, sustainable solutions is as much a matter of who's participating, but also, the content itself, and leaving that open to question to different diverse ways and what it means for justice, et cetera. I think that is advancing, but that's still a long way to go, rather than just sort of patting ourselves on the back by merely being a part of international law that maybe, had been taken for granted in, decades past. So I'll stop there for now.
Thanks so much, Daniel. It's a good way to sort of think about inclusion, not just in terms of individuals, but also in terms of states, I think, and communities within states as well. With that, we'll go to Anna. I think you're sort of the perfect person to help us segue into sort of the more legal parts of this discussion, and curious to hear sort of what your experience has been with respect to this topic, both personally, but also really professionally, because you are essentially charged with ensuring that there is diversity, equity, and inclusion at UCLA. And I'm curious about the challenges of that. How much of a sort of pivot were you faced with, and how is it going?
Thank you. And I just want to say good morning to everyone and good evening to everyone who's joining us. We are seeing your questions in the chat, and we definitely encourage you to add more. And thank you for being here. It's a pleasure and honor to be a part of this panel. Right now, if you are in international law, if you are in an organization, if you are working on behalf of a government, a public group, you should be thinking about how to advance diversity, equity, and inclusion. It is everybody's responsibility in the world. I am someone who comes to international law as a Black African-American woman who grew up in the United States. I have family and descendants from various parts of the world. On my dad's side, my entire family, he's the oldest of 10. My grandfather was the oldest of 17. They grew up not far from the once plantation in North Carolina, where they were enslaved and had to cultivate tobacco. And this kind of background, my own personal experiences with all kinds of discrimination, including very powerfully racism from the age of 5, which is my earliest memory of being called the N-word, have shaped my life, of course, and have shaped my career. And they've shaped how I approach the work that I do as an international lawyer, as a law professor, and now as a DEI leader. And I say that because I think, to the earlier panelists, Professor Pinto and Dr. Ngem, I really appreciate your centering the fact that wherever you are in international law, these problems exist. They still exist. So when we get on panels and we have conversations and we meet for conferences and we try to create strategies, there's often a call to look at what needs to be done without looking at who's in the room. And by who's in the room, I don't just mean, are the people in the room representative of society, of the global population? I mean, are the people in the room willing to look at ourselves? Are we willing to understand how we have benefited and how the current way in which in careers in international law, spaces in international law have privileged some and been detrimental to so many? And here in my current present day work, I have this lens on a couple of things. That UCLA is a big university. We have 100,000 people. We have global diversity. We have a hospital healthcare system. And one of the things that I think is important in 2021 and beyond, in light of all that happened last year, the reckoning around racism globally and here in America after the murder of George Floyd Jr. and so much more, is that we need to understand that maybe we rethink the ordering. We call it equity, diversity inclusion. I am seeing very powerfully that where spaces are truly inclusive, diversity happens easier, in an easier way. So this focus on getting so-called diversity, which means tapping individuals and pulling them into spaces where the spaces are sometimes downright hostile to their identities, is not, I think, the best approach for all organizations, spaces, or certainly for international law. I think back to the earlier stories. When you're on the floor at the Serpentine Lounge in the United Nations in Geneva, or before a court, international court or tribunal, what are the power dynamics? Why do certain people matter based on their identity, however defined? Who is not even allowed to say, this is who I really am? And here in international law, one of our greatest needs is to recognize as a field the right that people have around the world to identify however they are. And by here, I'm speaking specifically not only to nationality, national origin, race, ethnicity, but also to gender, gender expression, gender identity, and sexual orientation. And in knowing that in many places it is illegal to be who you are. And that is absolutely, as a field that's here to support human rights, equality, and dignity, unacceptable. So I think in international law, we have a lot of work to do, and we should think about a couple of things. Inclusion begets diversity. Where you see violations of civil rights or human rights, we need to link those to the mandate to advance diversity, equity, and inclusion. 3, we have to pay attention to intersectionality. Most people who are experiencing any kind of human rights or civil rights violation are experiencing across their multiple identities, not just one. And the conversation, therefore, about how to advance places that are safe and equitable and appreciative of their complex identities must take account of that. And finally, and I said this in the beginning, the agenda of advancing inclusion, the agenda of making sure that representation exists across a global society and voices are heard, and the agenda of establishing equitable practices and resources is everybody's responsibility. It should not be a side event. It should not be a panel. It should not be something that's set up as a committee in addition to the mainstream work of a group. It should be centered in the very core of the resources, the agenda, the strategic thinking about what groups exist and what we're here to do. Thank you.
Thank you, Anna. It's a bit of a call to action in some ways for all of us, and a useful way, I think, to kick off some of our discussions about sort of how to translate some of these ideas into international law, and sort of the way that the role of states is so critical to this. So let me kind of start off with a question. Namira, maybe I'll direct my first question. You can start with an answer, and then I welcome other panelists to join in. I think there's probably a lot of different opinions on this topic, but given that sort of we speak about international law, but it's somewhat not really international. How do we sort of integrate diversity, equity, and inclusion? Is the solution to not merely upholding state sovereignty? How does diversity, equity, and inclusion international law apply at the national level? In other words, who speaks for the state? Who within the state sort of has the agency to kind of make this a reality, and how does it kind of align with when we talk about international law generally? Are we taking enough account of the roles of the states in particular? And I know that you're working with the African Union, so really curious to hear your thoughts about this sort of relationship between state sovereignty and international law, specifically with respect to this topic.
Thank you very much. Actually, if we are talking about international law per se, if we go to the basics of international law, who are the subjects of international law? They are states. And since Westphalia onwards, the state sovereignty is the pillar in which states sit together in meetings, supposedly on equal footing. Here, when we are speaking about, I think Daniel mentioned that in relation to the equity and the diversity The problem is here, which I see in several experiences in different international organizations, the equality is different than equity. Because if we go to the GA, for example, we have every country has one vote. It's the same if we go into the African Union, for example, in all our contexts, every country, each will have one vote. But the dynamics, for example, in the General Assembly, the bigger countries, and you always see sometimes when some conservatives come in the US government, they criticize the UN, especially the GA, because they are put in equal footing with the smallest country on earth. So for them, of course, for a big power, this is something that erodes and undermines their authority. The same when it comes to the African Union in a different context, because also we are in the era within the African Union where smaller states somehow dictates decisions because they are the majority. Although the minority countries that are bigger and they contribute much, much more to the budget of the AU, but they are not having the same influence as smaller states. So if we're talking about the inclusion, here we have a problem when it comes to representation and inclusion. But if we try, and this, because this has become, it's been a narrative for a while in different scholarship, the issue of eroding the state sovereignty. But the problem is here, if you erode the state sovereignty, I believe it dilutes the responsibility of states. If we jump to the issue of human rights and international criminal law, if you do not have sovereignty, how can you hold the government responsible for crimes against humanity or for violating human rights law? So there are certain things we have to think it like from both faces of the coin. This is one of the problems. We have a de facto inequality, be it in the communities, if we're talking about the internal laws, or if we are talking about states. The inequality comes from the economic means that either the individual or the state has, the influence, because that is another issue, because in certain countries, definitely certain families have more influence than other families. It's the same if you go to the international community. On the organizational level, you will not have an equality. The problem here, when we are talking again about the inclusion and so on, in order to have the type of diversity and inclusion, it has to come within the laws itself. Then we will be faced with the hurdles of implementation. But if the rule is not there, if the rule is absent, then we will not be able to even fight for the proper implementation. For example, if we're talking about individual diversity that represents states in organizations, like we always speak about the IGOs, or if we are talking about even in the private sector, if we speak about women, you will say, okay, the women do not have enough representation, although now everybody calls up on all these institutions to respect gender equality. In the AU, we do have the gender parity in the higher levels that are elected, because in all the elected positions, it's half-half, 50% women, 50% men. So if we do not properly, like with the candidacy properly, then it's postponed. It happened in this executive council in this like few days ago, when I had, because I run the elections for the organization, I had to present that for the Pan-African University, we had received an all-male candidates for the position of president and vice president. So some states said no. In accordance with the entire rules of the organization, it has to be, we have to have males and females. And it's problem that we are presenting a full list of males. After a lengthy discussion, and to ensure that there will be someone to run the university until having everything properly in place, one position of president ran for the males, and then they postponed the vice president, requesting the other regions to present the female candidate. But we cannot find that in the UN, for example, because in the UN, you encourage women, but it is not set as a place for women. This is something also we have to think about, because if we are talking about, be it in the internal systems or in the international system, is the quota system the best way or not? Because it takes in perspective parts of the minorities in the community, but not all the minorities. If you think about, for example, in countries with indigenous people, if you do not have them there. This is a problem when it comes to the diversity and when it comes to the inclusion as well. So there are a lot to be said here, be politically or culturally, but I will have to stop to leave space for others to speak. Thanks.
Thank you so much. I think this is a really interesting topic, and you talked a little bit, I think, about sort of personnel and how that plays into into these sort of optics of diversity. But I also want to add another wrinkle to this and talk a little bit about sort of the policies and procedures and how those translate into institutional equity. Really to open up the floor, but maybe Monica, I'll hand it over to you to see if you have thoughts from your own experience, as well as some ideas in terms of how can we actually take diversity, equity, and inclusion and translate them into policies and procedures that sort of govern the international institutions in a more deliberate and effective way.
Thank you so much, Henny. Thank you so much, Ambassador. It's very important listening to your concepts. I was, when you put the remark that I've been dealing with human rights, I started thinking on international law as we have learned it. And in fact, when you think who makes the law and who enforces the law, you see there the imbalance you were pointing to. If you take the ILC, the International Law Commission, there you have a great imbalance between the different groups. 8 members for the Western European and other states group, 8 for Africa, 7 for the Latin America, 7 for Asia, 4 for Eastern Europe. However, when you take into consideration who are appointed as rapporteurs, you come to the conclusion that 14 out of 31 rapporteurs in the life of the Commission so far are coming from Northern and common law countries. That means, putting it very roughly and in a very marketing way, that treaties, custom, and state responsibility have been drafted by white, male, generally from common law system, generally from the North. When you are coming to the enforcement of the law, well, okay, the ICJ is more or less balanced because there you have the regional groups. Is not balanced in terms of gender because only 4 women so far have been sitting there, but that's something that we can go. We all know, perhaps because I'm senior than the great majority of you, that the law is important, the culture is important, but it is also important to move like that, to make room in order to get into the situations. Once there, you can discuss in a different way. But if you take into consideration arbitration, foreign investment arbitrations these days, taking into consideration the last statistics by ICSID, you can say roughly that 88% of the cases regard the rest of the world. What I do mean by the rest of the world, putting aside Western European and other countries group. So you have that all the world comes there in this 88%. And this 88% is decided by tribunals where the majority are male, European, and North American arbitrators. In the whole, 88% of the arbitrators are male and only 12% are women. The point is that we can't be so bad so as not to have the possibility to apply to the lower step in this career. The point is that we have to make up our minds in order to allow policies that could enrich this society. For the ILC is not difficult. For the ILC is not difficult, but it's not for the ILC, it's for the states. We have to persuade our governments that they have to propose candidates, and their candidates have to be good in order to be there. I'm so sorry, perhaps what I'm going to tell you, you don't agree, but I've learned throughout my whole life that being a woman, I have to study a lot. I have to be better than my partner who's not a woman, because we are not allowed to be medium size. So that's the same for those that are representing states from the third world. They have to be good. If they are not good, they are not heard. If they are not heard, they don't have the possibility of having an influence and changing the policies. I think that a lot of progress has been made in recent years, and we are very happy of being there in order to witness for the changes. I'm not saying I'm the most senior in the world, but I do have the responsibility of mentoring and helping the younger women that are near me. This is something I have to do because of my girls, because of my grandgirls, and so forth. But at the same time, we have to persuade our government, our authorities, in order to make room for people that has to be there, and to make good room in order to vote, to propose, to support candidates from other parts of the world, candidates who are not neither men nor women. We are not talking about other genders. We are not talking about genders in plural. Nobody understands gender in plural. And that has to be done. They are there. We're not changing anything with law. We are simply helping them to have a better quality of life. So we do have to work on that. And I think that, as Ambassador said, this is a very much state-made world, the world of international law. So our states, our authorities have to be persuaded. Thank you.
Thank you so much, Monica, it's a passionate call in terms of, both what we need to do and what's still lacking in terms of our commitment to this issue. I wanted to see if Daniel or Anna wanted to chime in. Daniel, I know you do a lot of work in this sort of space regarding kind of state sovereignty versus international law. So I wanted to know if you wanted to chime in on that particular question.
Yeah, no, in some ways, I've had the pleasure of, this can sound like I'm saying that Professor Pinto repeats herself, but unfortunately, while these things are still true, she has to keep making the same arguments. But on one hand, it's so obvious. I say that as a compliment. Let's use the International Law Commission as an example. Yes, it is states who nominate these people, but you hear, whether that's across gender, across race, or about the challenges, say, special rapporteurs, the sort of statistics that Professor Pinto read out are equally true with respect to special rapporteurs from the global south, let's say, in some ways even worse. I mean, all four of the, which is appalling to say that, all four of the current, and there's an election this week, ILC members who are female are a special rapporteur or in charge of, historically they've all been involved, but that's, 7 of 7. There was this, 7 in 70, so it's not really saying that much. Whereas obviously a huge number of obstacles, and you hear this, the one that it is states, and there is that important of this massive risk aversion, quote unquote, of why states, and we have to go with the people we know. First of all, nothing is stopping if you were a candidate proposed for a judgeship, or you could say no if you were, a man in that country. And similarly with working methods of the International Law Commission, there's often things, let's say, we want to hear more from, say, small developing states, but the process continues. And they could do things, say, look, until we get more statements, more oral or written statements and participation from these states, we're not going to go at a pace, which would have a more radical transformation to say, there's no requirement. So in that sense, these things are all true. Yes, but putting it on the people, Ambassador again, like the whole panel, to sort of persuade states. I mean, it's going to become self-fulfilling, because then it's the same sort of representatives, same countries, same genders that have the experience. So then if you're, and I was listening to a panel yesterday all about representing states, then if you are just like, oh, we're faced with a case, you're going to do the thing that basically makes you look least likely responsible for failing the case, which is, if I hire the, massively old white dude who's done 100 cases and we lose, it can't be my fault as, Minister of Foreign Affairs, because or we hired this big law firm. Putting some responsibility back on those individuals themselves to say, maybe I shouldn't take every single appointment that's thrown away, or I'm going to demand that at an absolute minimum, the people sitting with me or the people working with me are representative of all the different forms of diversity we're talking about. That's the only way they're going to change. And then just slightly uniting the 2 points, I think that Ambassador Gem said, there is this aspect of who speaks, who's representative, and then the content of the law itself leading to sort of equity. They are intrinsically connected, but often talked about in 2 different conversations. So on the one hand, it's important, representative, and then the law itself. I don't think they're going to get the latter, the real transformation in the content of the law to achieve equity without actual DEI across all these matters. And very much in line with what Professor Bradley said, the reverse is also true. It's only by inclusive laws that then you're actually making it, easier and responsible. But that's some comment there.
Thanks, Daniel. Anna, I'm going to turn to you now and welcome your thoughts on this question, but also wanted to ask you a separate question, which I think you might be sort of in a unique position to speak to, which is what would a real commitment to diversity, equity, and inclusion look like with respect to the teaching of international law?
Thank you. And I'm looking in the chat and seeing more questions, and I just want to call out the last one by Jessica. How can you persuade smaller states to start participating? And to bring that into the former question before reaching the teaching question. So if we look at 2021, where are we? We have a COVID crisis around the world, and not just one COVID crisis, but several, because the approach to dealing with COVID has been highly inequitable. And we all can see that from different vantage points. We have a climate crisis. It is here, it is growing, it is intensifying. And from the perspective of international law and related fields that exist to serve a purpose of allowing the global community, however defined, to best approach global challenges, it is imperative that these tools make sure that we can do that. Which is another way of saying DEI in all of its formations is not at the periphery of the conversation. It is the conversation. And by that, I mean, if you do not, as an international United Nations or other international organizations, or you do not as a state appreciate the need to bring all peoples under this conversation, we're not going to succeed. And I say that to say it with a sense of real urgency. I know that our states and others are meeting right now at our Conference of the Parties. I was involved at Conference of the Parties 6 with the United States at that time. And I remember the hope then. And now I think we just need to impress upon these conversations a sense of urgency about the fact that we can't do business as it was. It doesn't work. I will flip from that to talk about international law and teaching of it. I wrote a book recently called Human Choice in International Law. And in that book, I talk about how people make the law. We can talk about it as state behavior. We can talk about it as state consent. But at the end of the day, until we have artificial intelligence, it is human. It is somehow human. Which means it is also somehow the best of us, our values, the worst of us, our biases, and more. And in that, I had the chance to interview people who were in the room at the UN Security Council who didn't want to be attributed in the book, who were present and involved with the decision to intervene and use armed conflict into Libya. And a couple of things came out of that story. Some people made that choice, or they, in their own words, because they thought, oh no, we have to prevent the next genocide. It is that imperative. And after they made the choice and events unfolded on the ground, civilians died because of the choice. It's complicated, it's difficult. They had regret. And they recognized in some form or fashion their own biases. And this goes into the teaching. There's a big conversation when we teach about universalism versus cultural relativism, which are fancy ways of saying Should there be global values? Should we have the Universal Declaration of Human Rights that prioritizes individual rights and certain kind of Western-centric ideas of human rights? Or should we appreciate that those sorts of values should be growing up in cultures linked to the spaces and the people who hold them dear? And there's a big tension between those two views. And I see that coming into the conversation about international law back to state centricity. And when we teach international law, when we practice, when we look at who's who on the international arbitrators list, when we think about so-called leaders in the field, we've often reprioritized the very power structures for which we're saying international law today fails. And in teaching international law, we've had a revolutionary conversation in the field in the last few years, calling out all the ways that textbooks and lauded authors are not telling the whole history, not telling the whole story. And here I will go to Grotius. Any student of international law is familiar that Hugo Grotius is often deemed the grandfather of international law. Why? Another question might be, well, who's not also deemed grandmothers and granddaughters and other people of international law? Grotius himself, in the history of his life, was part and parcel to, if not actively supporting, at least advancing means for the transatlantic slave trade. And in that moment in the 1600s, everyone who could was making money off of the transatlantic slave trade. So when we talk about understanding new perspectives for international law and teaching it today, it's not to say that you shouldn't talk about Grotius and his contributions. It's to say, tell the whole story and situate the whole story from people who were harmed by that version and that creation of international law. There's a lot of new authors and a lot of new scholars who are contributing to the broadening of perspectives in international law. And for anyone who's in that space, as a student, as an educator, professor, as a scholar, we are revolutionizing the norms. In 2021 and beyond, it's no longer good enough to teach international law the way that it used to be taught. It has to be inclusive. From a global perspective, it has to include voices who have not been included. Thank you.
Thanks, Anna. It's an important perspective, and it's also, as I said, an example of how much work we still, I think, have to do to elevate diversity, equity, and inclusion sort of in the international law space writ large. I'm going to turn, I think, to, as you mentioned, to a question in the chat. I'm sure folks on this panel have differing perspectives on this, but I think it's a critical question. And then also I have a follow-up question, I think, which is a bit different. It's more focused, I think, on your personal sort of understanding and what we need to do going forward. But let me start with Jessica's question, which is, how can we persuade smaller states to start participating more in the international sphere? Would anyone like to jump in?
I can. Smaller states actually do have a say on the international sphere, and they do play a role, but the role they play is confined to what is so important to them by virtue of their size, by virtue of their capacity. Because if you're talking about some, especially in CARICOM, the small island states, they do borrow even experts from other nationalities to assist them in the UN, for example. But they do not have the capacity, financially even, to have a big delegation that will cover everything in the UN. And they cannot have representation in the UN in Geneva and in the UN in Vienna and the Habitat. They can't. So they do play a role, but they prioritize. This is where actually, if you're talking about inequality of representation, I'll bring an example. When I was a junior in The Hague, the Hague Conference on Private International Law is a small organization in comparison to even the AU or the UN. And they discuss things that are crucial because the conventions they adopt is not only about the conflict of laws and which is applicable, but it addresses issues that touch on the human beings in their countries, like the recognition of marriage, the recognition of divorce, some of these issues and what to be implemented on it, recognition of judicial decisions. In one meeting, I think it was like on the span of 2 years, it was a convention, I will never forget, securities held through intermediaries. Because for me, as a diplomat, even with the legal background, when I was a junior, to understand what is securities held through intermediaries, where I have nothing to do with banking systems, it was very difficult. But you can see that some of us, we were one, some of us were two, have instructions from back home, and you have a delegation of the big countries, which the delegation itself, the official delegation, constitutes of 10 to 15 people. And you have representation in the industry who are part of the discussion as observers. The funny thing is when we say something, and we're talking here about governmental negotiations, but at the end of the day, I'm one, I'm speaking as one. Then I'll compare myself, for example, to the Chinese or the US delegation. The US delegation, yes, when the delegation speaks, it's one. But then when the time comes for the industry to take the floor, we have 10. So whether you are trying to defend your interests as a developing country versus the other part of the world, it is extremely difficult. But at the same time, in the UN, you would see, for example, the small island states are extremely active when it comes to climate change, when it comes to the issues in relation to law of the sea because of the sea level rise, and they want to institutionalize their issues. I remember it was a fight to bring this to the Security Council, but for them, it's a security issue. So this is how the smaller countries do contribute, but you cannot ask them to contribute on everything. Even if they have forests, for example, they may not have the ability to bring experts to sit in the negotiations of forestry. So this is how it is. To convince them is to give them support and do capacity building. This is how you can support them in order to make sure they play a bigger role. But before this, without programs to support the small countries, you're asking too much of them. In reality, they cannot do it, especially when they are facing with natural disasters, with things that already consume a lot of their national resources. So this is an extra money for them. And even if they have qualified people, they may not be able to afford them. Thank you.
Thank you. Daniel, I know this is a topic near and dear to your heart, so I want to give you, we're running up against the clock, but wanted to give you a few minutes to chime in on this particular question.
Oh, thank you, Sina. Well, everything that Ambassador Kim said is obviously entirely accurate. So, the question, I do want to disaggregate some of the states and issues, both solutions and the uniformity. So, I mean, exactly as Ambassador again, you were forced into prioritizing and being a significant voice in particular areas. With that challenge, I would say, look, not all small states are sort of uniform. There still is, and this goes back to sort of the, at least what I took away from Professor Bradley's initial point of the interconnectedness between the sort of form and the content of DEI, which is to say that if they're not engaged, if they're not part of that process, it's then much more likely to feel, why are we going to comply, enforce, even participate? So again, there's that role of changing the content of theme. Of course, this point about having to prioritize as small states therefore means there are whole areas and topics that just the majority of small/developing states are not speaking into and up to. Are there strategies involving delegation or groupings? Yes, but of course, there's something that's always slightly watered down. I mean, you can't transform magically the political or economic differences, but at least forced always into sort of big groupings at times, not, yes, every, Pacific Small Island developing state has pretty similar concerns concerning sea level rise, clearly. But let's say that's not necessarily true in terms of economic matters or international criminal law, let's say for the Africa group per se, but sometimes that means the loudest voices aren't the most representative. So then how to support that process? And I think, as Ambassador Nigam said, it's a combination of saying, that goes to our sort of previous conversation as well. It's easy to say, it's not magic, it's not rocket science in that sense of, if you, all of the analogies, if you had the resources and the size of delegation of the United States or China for any small developing state, they'd be able to participate more. Given that isn't a reality fully, but how can we still increase that from a strategic point of view? And one of the things with international law for states is showing how it can impact and transform before things go wrong. That is kind of the matter. Even the smallest state will find the resources to sort of bring in a big law firm, bring in a Professor Pinto at that stage, but you want to bring in be strategic about when do you need the expertise at that early stage, due diligence. That is partly, a resource matter, but from a strategic point of view, how do you institutionally change that? And it's obviously the heart of the organization to say, look, at an early stage, let's bring in an expert of that kind of stuff. Let's turn to someone who's, focused in this particular area. Let's at least know our position enough to engage with others. And then finally, I would say, of course, it's also perhaps echoing my comment before, similarly, put it back on, it's easy to say for the bigger state, but for a small state, if those, you have to perhaps not roll forward so many, say the ILC again, just as an example, of course, it is much harder to contribute or written comments. How do we change the working methods or to slow things down? You have these debates constantly, and it's happening right now, obviously, during International Law Week between the 6th Committee and the ILC. It's, every time you see an ILC member, and it's not personally attacking them, saying, we want to get more contributions to small developing states. I know my work product and our outcome is much less rich. We haven't heard from them, but it doesn't slow things down. I mean, these conversations seem sort of to happen every 10 years and do it again, as opposed to building that in and saying, even in all treaties, but for the kind of capacity building and technical assistance and resources, what kind of obligation transformation, again, that's easier said than done, but that kind of longer term transformation needs to be built in. Thank you.
Thanks, Daniel. And I know that you spend a lot of time and energy and brain power sort of looking into this particular question of sort of how can we empower small states to have more of a robust voice in the international system, and it's good work. We are sort of hitting up against time, so I wanted to kind of give all the panelists a chance to weigh in on a question that came up in the chat, which is what more can we do to hold sort of malign actor states accountable for their violations of human rights. But I also wanted to kind of end kind of where we started on a bit of a personal note and ask each of you to kind of chime in terms of what advice would you give young attorneys who are looking to work in this space from a kind of personal heart level, or I guess since we're so close to the end of our time, what do you think is the most critical way that we can advance diversity, equity, and inclusion and move the needle over the next sort of 5 to 10 years, obviously focused on international law, but if you have one priority that you wanted to single out, I think it would be interesting to hear what that is. I also just wanted to say, and I said this to this group of extraordinary people at the beginning, that it's just been an honor to have this conversation with all of you. I think, in your own ways, you're all breaking barriers and inspiring, not just, generations of women, but with Daniel here, generations of international lawyers. And so, I think the work that you're doing is just truly outstanding and inspiring for me. I'm sure inspiring for all of those who you sort of meet, whose lives you change and affect just with who you are and the work that you do. So just so grateful to have this opportunity to speak with you all. And with that, let me give you all a chance to sort of chime in with just a few parting words. Maybe Monica, we'll start with you.
Thank you so much, Sohini. My pleasure again to be with all of you colleagues and with the big audience that we can see. I think that with a more diverse world is more interesting, is more rich, and we can learn a lot from diversity. When we are there, we learn a lot. And the more, for me, perhaps in a strategic move is how to choose a partner in order to get to the right position in order to try to change a little bit the needle, as you say. So the choosing of a good partner is important. And I'll stop here. Thank you again.
Thank you, Monica. Ambassador, over to you.
Thank you very much. Actually, if there is one issue I would rather we focus on when it comes to diversity and inclusion, I would say development and youth empowerment. Because I believe in the world we're living in today, with especially coming from Africa, where we have the biggest youth population, and also facing problems, not only because of the youth population, but also because of the flow of illegal migration and even the violation of some of the developed countries to the conventions on migration and refugees. I think this is crucial for us to have inclusion of the youth when we are addressing the issue of youth. The issue of everybody should be there when we are addressing the issue of development, because it differs. Now I'll go to the individual, because it differs from one experience to the other on the international level, even to bring the voice. So in our countries internally, when we formulate policies that we will have to defend internationally, I believe we have to have such inclusion, such diversity, and to bring it to the international sphere to make sure the voices are heard. Thank you.
Thanks. And sadly, we're at time, but I want to give Anna and Daniel the last words. Anna?
Just quickly say to everyone, you really can appreciate the role of international law in all of this in the future, if international law can evolve. What happens when you don't have human rights violations? What happens when you get diversity, equity, inclusion right? People experience dignity. It's that simple. So if we can each in our world, in our spaces, treat one another with dignity and disrupt all the things that get in the way, we'll be halfway there. So thank you for the opportunity to be here today.
Thank you so much, Anna. Daniel, over to you.
Last words. Well, thank you all, my panelists. I've learned from them both today and in general. And I think in sort of echoing in Professor Bradley's comments in the sort of question before about even teaching and in general, for my panelists, you know, if whatever place you are at, whatever institution you're setting, if you look around and formally it doesn't look like this is a diverse group of individuals, but what you're hearing and even the content, everything which you're doing international has to be tied back to these things, both in its intrinsic and substantive values. And if it's not, you need to be thinking on what you can do, what institution can do to sort of make those changes. Otherwise it'll just continue. We'll be having this panel another 50 years, different people maybe, but same content, less changes are made. So and thank you for your excellent moderations.
Oh, thanks. And like I said, it's really been my honor to be with this extraordinary group of folks. And, Daniel, I know you're the sort of only white man on this panel, but we need you too to be fighting for these issues. This is a project and a mandate that requires everyone. So I hope that, we all will go forward in our work and continue to elevate these issues, to make sure that people pay attention to them and that they don't get sidelined, because as I think, Anna said, with and frankly, all of you have said, a diverse world and diversity, equity, and inclusion within international law is just critical. It's going to make the world a better place for all of us in the end. So again, thank you to the inspiring work that you all do and for joining this discussion. It's been a real honor for me, and I hope everyone has a wonderful weekend.
Thank you.